Hi everyone. I had the chance Monday to be a faculty presenter at a continuing ed conference that dealt with pain and suffering damages in personal injury cases. And I spoke on sort of generally what pain and suffering damages are and then how insurance companies evaluate those. And in the course of my presentation, I gave some tips to the attorneys on how to make sure their clients can maximize their recovery if they are involved in an accident. Now, sometimes there are people out there that don't want to hire an attorney to negotiate or resolve a personal injury case. They want to do it on their own. And we do get calls from those clients or potential clients that kind of just want to pick our brains on how to approach it. And we're happy to do that, give them some information and some pointers if they're going to represent themselves with the insurance company, things they need to do and be careful of. So I thought I'd take a couple minutes here and just go over kind of 4 things that you need to make sure you're doing with your case, your personal injury case, if you're representing yourself, to maximize how the insurance company is going to evaluate that case. The first is, if you are injured, go to a doctor, whether it's your primary care physician, the emergency room, or an urgent care type facility. You need to go see a doctor. Usually the sooner the better. Now, for some folks, they don't feel any of that pain or discomfort until the next day, maybe the day after. If the injury occurs on a Friday, sometimes they'll kind of gut it out over the weekend to see how they feel come Monday. But as soon as those symptoms become problematic enough that they're causing you discomfort, you need to go see a doctor. Number 2, hand in hand with going to see your doctor or a doctor, is make sure you report everything that is bothering you that you feel is from the accident. When you see the doctor and they ask you, so tell me what's bothering you, give them an exhaustive and comprehensive list. Reason being that when the insurance company or the defense attorney reviews the medical records, one of the things they're going to look at is, when did the symptoms first find themselves documented in the medical records? Were they the first visit or were they the 13th visit? The sooner in time or more contemporaneous with the accident that the symptoms are documented, the more likely an insurance company is willing to accept that those injuries are in fact related to the accident. If the first time something is reported is 3 months after the accident, there's very little chance the insurance company is going to be willing to accept that injury or those injuries as being related to the initial or original accident. The third thing that again kind of ties into the same theme here is you need to keep medical appointments, keep physical therapy appointments. One of the things insurance companies look at is what colloquially in the industry is called gaps in treatment. It's one thing if you miss one physical therapy appointment here or you miss a doctor's appointment here because you had to reschedule. But if you miss a big period of time between appointments, that is a red flag for insurance companies. The idea being that if your injuries are bad enough to warrant seeking out medical treatment, they should have been bad enough that you kept your appointments, meaning you needed the treatment or the therapy that was prescribed for you to help you deal with your pain and discomfort. So if you miss 2 weeks of physical therapy in a 6-week physical therapy plan, you can definitely expect some pushback from the insurance company on how they evaluate your case or how they evaluate the pain and suffering portion of your case. Number 4, social media. It's a little bit ironic since we're posting this video to social media, but be very mindful of what you put on social media when you have a pending personal injury case. The most innocent and seemingly innocuous post or photograph can possibly be spun by the insurance company or defense attorney in such a way to discredit or in an attempt to discredit your testimony or presentation you're making about your pain and suffering that you are dealing with or had to deal with as a result of the accident. One of the first places defense attorneys and insurance companies will look is social media. I recall one case I had where I was defending the driver of a delivery truck for a package delivery company, and he had done significant damage to the plaintiff's vehicle when he rear-ended it. The plaintiff alleged throughout medical records, throughout his deposition, throughout other discovery that we exchanged, that he could not do anything after the accident, couldn't work, couldn't earn a living, Well, when we did a search on social media, we found a bunch of stone walls that he had made in someone's garden, including his own. All of these photographs were posted after the accident and were one of the pieces of evidence I used in the jury trial. I had them blown up to poster size, and after he testified on the stand during direct and cross-examination that he was unable to work, unable to lift anything, I flipped them over and began to question him about those. The jury had some serious issues with his testimony versus what we were seeing in the photographs, and that impacted the award that the jury ended up giving him. So keep your business in terms of your injuries and your accident off of social media, and there'll be nothing out there for you to have to worry about the insurance company's finding. All right, thank you, everyone.